Have you ever tried to explain what your ex did to a lawyer, to the police, to a judge, and watch their eyes glaze over or look a bit confused? You know in your bones that it was abuse. You've listened to our episodes. You've heard what types of abuse there are. But you've said it out loud, and when you do, each little bit sounds so small that you're worried that no one's going to take it seriously when you say, they gave me the silent treatment or they controlled the money. And you can see them thinking, is that all? And so this episode is for everyone who has felt that, because today we're going to be talking about proving it. If you're new here, we began with a single listener question that has grown into a 6-part series on coercive control, where we've been answering them alongside our special guest for the 6 parts, clinical psychologist Krasi Kirova. And if you haven't already hit subscribe so you don't miss the rest, if you're safe to do so, could you please hit subscribe so you don't miss any more? Or you can go to thedivorcecourse.com.au and subscribe to her.
I'm Laura, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
Our newsletter, where we can stay in touch more privately. Krasi Kirova is a clinical psychologist and a board-approved supervisor who helps people break free from the worn-out familiar patterns that keep them stuck. She draws on both her professional experience and her own first-hand family experience, and she has a deep interest in supporting people through domestic violence, coercive control, and emotional abuse. And of course, we are also joined by my amazing mother, Lynette Galvin, an accredited family law specialist with more than 35 years experience, here to walk you through the legal side of things. Also, I might add, Mum's birthday is coming up very soon. So happy birthday, Mum.
Thank you.
So this is part 5, and this is one so many of you asked for, because last time we were talking about children, money, and all the things while you're living under one roof. But now we're talking about how to prove it, the evidence part. And it's so exhausting to name those moments. We were talking to someone today, Mum, in our Q&A, weren't we? And she was just struggling with how to put it into words without it sounding silly, or to her, it just didn't sound like it had enough gravitas, and trying to get this into documents can be really hard. So we're going to be working through that side of things in this episode and answering the questions that you've sent in to hopefully help you and other listeners going through the same situation. Just a disclaimer and a trigger warning. Before we start, today's conversation will cover coercive control, obviously, family violence and emotional abuse, and some of it may be hard to hear. Please only keep listening if it feels safe to do so. If you need any support, you can call 1-800-RESPECT, or you can call Lifeline on 13 11 14. If you're in immediate danger, of course, always call the emergency services in your country. In Australia, that's 000. Everything we share today is general information to help you understand your situation. It's not psychological or legal advice, so please always get your own independent advice before you do anything. Okay, welcome, Krasi.
Hi, Laura, once again, and hi, Lynn.
Hello, Krasi. Hi, Rosie.
Yes, by the way, my name is Laura Rose, so people always ask, why do they call you Rosie? So just in case anyone's wondering whether I'm pretending I'm a different person, I'm not, I'm the same person. Okay, so let's get into the questions, because there's a lot here that we would like to get through. And so we're going to be looking at affidavits and what the court's actually looking for, and this is really about making it count. So Stacy's question was, how do I make my notes matter when I go to court? I've been keeping notes for over a year now about things my ex has said or done and that I deemed anxiety-inducing or controlling. At the time, I felt like my world is collapsing, but when I read them later, it sounds petty or minor. What evidence most effectively demonstrates a pattern of post-separation coercive control when each individual incident appears minor or reasonable or capable of innocent explanation in isolation? Let's go to you first, Mum, and then we'll talk to Krasi about how she helps her clients deal with that kind of thing.
Yeah. So I want to say to our listener, what's her name again, Laura?
Stacy.
I'm going to say to you, Stacy, that your words and your language explaining this situation are not lost on the judge who ultimately decides your case. They are very well informed about the forms of family violence and how that might appear. So basically, take the things that have happened to you, try to put them in a little bit of order, name one or two very specific incidences and put in there how you feel, and then have faith that the judge will, looking at that, will be able to detect that pattern of abuse. And I've been reading up cases for how the court is treating coercive control and family violence these days, and I have been very heartened by the way the judgments quote paragraphs out of the affidavits of people who've been subjected to coercive control. And on some occasions, the person who's the abuser doesn't get to see their child at all.
So, Krasi, why do people struggle with the fact that they feel like what they're writing down feels petty? What can you say to Stacy to help her get through that?
Yeah, I would say to Stacy what I think I say to everyone who struggles, and that is most people. It is such a struggle. It is so difficult to see it because it only makes sense in its entirety. It very often doesn't make sense when you just look at one individual incident at a time. The way I like to think about it is like revealing a puzzle. If someone gave you just a few pieces of the puzzle, there is no way you can make up what's the whole picture. You might be seeing part of the sky, you might be seeing part of a tree, who knows? But when you put all the pieces together, that's when you make a cohesive narrative and cohesive sense of what's been occurring. And with coercive control, that's exactly how it makes sense. It's not like other crimes or other instances of abuse that can be very incidental and one-off in nature. That is not the nature of coercive control. It is the opposite. So you can almost think of it again as a death by 1,000 cuts rather than one big slash that completely harms you. The death comes over time. It is because of that cumulative harm that occurs. And very often, each individual occurrence on its own, if there was no context around it, if there was no framework to contain it, it wouldn't seem that big of a deal. So that's the real difficulty when someone is trying to put it, I think, in an affidavit or explain it to anyone else. They're having to explain a whole context, a whole regime, a whole dynamic of a relationship over multiple years very often, in the space of maybe 10 pages for an affidavit or half an hour that they have with a professional. And so people are struggling to pick out what's the worst here, what can I put forward that is going to convince them when the picture can only be seen because something has occurred 100 times, not just once. That's where the real harm has come on because of the repetitiveness and the relentless nature of it. And that is, I acknowledge, that can be very difficult to convey with limited space, a limited number of pages, and also, to be fair, with limited understanding sometimes from the people who are hearing your story. I think even nowadays, I think there is a very patchy kind of training and level of professional understanding amongst a whole range of people who work in this area. So it is a matter of luck sometimes who gets to read your materials and who you're bringing this up to. But what Lynn was saying, you have to tell your story. You have to build a picture, even though to you, it may not feel that big and significant.
I just want to say, I am aware of self-repped person, and the judge identified the pattern themselves. The judge noticed the pattern and created some safety and some workarounds for that particular person in court. And I know that's just very recent. So she didn't even have to point it out. The judge noticed it. So yes, I understand that it's really hard to get it across and communicate it like Krasi's saying. And I see what Mum's saying. People are paying attention, and I do agree. I think it's a bit of both. And I think it does come down to how you convey it as well as who you get to read it. It is a bit of a, what do you call it? Not an algorithm, an equation. And if you're lucky, you'll get a good output and a good reader. But let's move on to some of the other parts in regards to this, Mum. And what is it that the courts are looking for to impact a victim's share in property settlement if they've experienced coercive control? What kind of things are the courts looking for in order to be able to get a larger percentage of the property pool?
So what the court's looking for with people is the behaviour of a person, presumably your ex, and that behaviour made your contributions to the marriage, whether it be raising the children or like keeping house or whatever it is, that made your contributions so much more arduous than if you'd been married to someone who wasn't coercively controlling. And so I know that this is probably what you would be talking about, Krasi, more, But it is an issue of emotional regulation sometimes with a coercively controlling person. And often the mother steps in or to protect the children from the emotional dysregulation. And so the court can take notice of some of those things by life experience and common experience. So, for instance, if there's been alcoholism as well as, or alcoholism on its own, I guess, or if there's been bullying, triangulating the kids, all of those things within the marriage, it is hard for you. It was hard for you to do your job because you've got this extra issue running around. I read an article on the weekend called Living with an Angry Man, and I think that just, really struck home. So, yes, you just say it, Laura, and say how it impacted you. I used to have to get the kids to bed early because if he came home and he was angry, if he'd had a bad day, I didn't want them to see it. I used to cook twice their meals early and get them out of the way.
Right. So what you're saying is, and I just want to point out that I do know that we have some listeners who it is the opposite. It is happening. It's the woman that's causing the coercive control to the man. So let's just make sure we're aware of that. But when Rachel says, what is it that courts are looking for to impact a victim's share? And what you're saying, Mum, is if they made your life harder, if you had to do extra work to accommodate, or if it's affected you in a way that you're going to struggle in the future. That's what the court's looking for.
That's right. And the court in Shaman, S-H-A-M-E-N, I think, or O-N, and Shaman, that was a case where there had been SA of a young daughter throughout the relationship, but they didn't find the mother didn't find out till after separation. And so the court used that, the court found that he shouldn't have time, and the wife got an extra percentages of the property pool because her life was made harder because of this was going on. And he argued that the mother didn't know, therefore it couldn't have made her contribution harder. And what they had was a child who was just, really crying and tantruming.
Hard to manage. Yeah, of course.
Hard to manage. And then, of course, so that argument fell. And the court also said, and there's going to be an ongoing impact from that.
Okay. All right. So, so that's important to note. Sometimes the judge leans on your affidavit, your words as the proof. You saying it is the proof, and the judge needs that information so they can put it in their judgment. And if you don't tell them, they can't sometimes make those decisions because you haven't given them any proof. Okay. And the proof is you saying it happened. All right. So let's get on to Anonymous. Her question was, this is a joint question for Krasi and Lynn. My husband was coercively controlling and financially controlling in our marriage. This included frequently engaging, and just a warning, guys, this is quite a graphic one. So if you've got kids, please fast forward this and please call 1-800-RESPECT if this triggers you. This included frequently engaging in unprotected sex with sex workers in our home, which I found out because he had filmed himself. When I confronted him, he vehemently denied it and became enraged with me for daring to question him. Later, I discovered he'd told people we'd separated because I was having an affair, and this caused incredible distress and affected me physically and mentally and my mental health. I'm preparing my affidavit now and want to know, should I include this behaviour in my statement? I understand we have no-fault divorce in Australia. However, should I include the circumstances of his infidelity as an illustration of his abusive behaviour?
Right. Right, you should. Yes, absolutely.
Okay.
Yeah.
So
it is. Yeah.
Just to clarify, because I think some people get confused, the no-fault divorce doesn't mean their bad behaviour doesn't somehow affect property settlement.
That's right. Okay. Or the children. The no-fault divorce in Australia just means that you don't have to, when you go to get a divorce, which is completely separate to every other thing you do in the court, you don't have to prove, like they used to in the old days, cruelty or desertion or any of those things. So it just says you've been separated for a year. Yes, here's your divorce.
Yeah. Okay.
So then you going back to this behaviour. Of course, that's made your life difficult. And his reaction when you asked him about it and putting you at risk. If you didn't know, then you probably had to go and had to go and tell a doctor, get some tests done, all of those things. Put those in. I have seen those over the years as a kind of the court puts that in as the behaviour.
So that in evidence that she had to then go and get tested and checked that she didn't have any diseases, etc. Okay,
Yeah.
Krasi, what do you have to say for Anonymous?
Oh, I agree very much with Lynn that it sounds to me like very relevant behavior that absolutely should be included, especially when it's put into the wider context of other behaviors that seem to be occurring in the relationship. The listener already mentioned there has been financial control, and it sounds like other controlling behavior as well. So putting it in there really is building up that pattern. What is being described in this particular situation is there is very significant brazency and just profound disrespect by bringing and filming in your own home sex workers, which goes way beyond just simple infidelity and cheating. There is the violation of trust and safety of the intimate relationship in the family home, but also of the health of the partner, because I have also heard plenty of cases when there has been an STD transmitted through this way.
Yes.
And it's a lifelong thing, yeah.
Yes, and they don't tell the very angry reaction from him. I don't know if you've seen this, but over the years, I think some of these behaviours, we do have a narcissist playbook, but honestly, coercive control playbook pretty well always includes sex workers and disloyalty and putting people at risk like that. It's just...
Yeah. Okay. And I think, Lynn, what you're mentioning about the response reaction, that is what we call DARVO. So the deny, attack, reverse victim offender, where not only are you completely lying and saying no, but then you're reversing the whole situation and you're making yourself to be the victim of what you have done, the harm you have caused to the other person. And that's why sometimes to my clients, I will say, there is so much projection in these relationships that if you get accused of something that seems to be coming out of nowhere, you should be thinking, are they doing that exact thing? Because why else are they coming up with this accusation? So in this case, that is a clear case of DARVO. And I even wonder, even if the listener themselves doesn't fully recognize the extent of what's happening, if it's all put into an affidavit and all seen by a judge, maybe they will put together the picture, because from the outside, as an observer, it sounds pretty bad.
Yeah. Big hugs, Anonymous. It's pretty... If anyone wants to listen to our episode on DARVO, where we talk about how abusers use DARVO in the family court, go and listen to that episode. I'll put that link in the show notes. Now, let's get to the next segment, which is working on what counts as evidence. And I know we've touched on it a bit already, but let's get into these questions. Wynn's question is, what can I use as evidence? For example, is it legal to use voice memos or the home security footage as evidence? If you have had a conversation a while back telling him you're going to record him and he consented, and there's another question I'm just going to add to that from Anonymous. I'm not sure if it's the same Anonymous or different Anonymous. Is it illegal to record a conversation between me and my controlling spouse without their knowledge? Mum.
Okay, so it's different rules if you're on the phone, but if you were part of a conversation between you and one other person, there is no... In my experience and where I've, studied, there is no law against recording a conversation to which you are a part. You actually, I don't think, need to get the consent of the other person. In all my years, I've never told my clients to get consent because, and when you go and put this evidence before the court, if you can't put the recording in, then it is your word against theirs. And if it's something that is relevant to the safety of you or the children, the court has the power to waive the usual rules of evidence anyway, okay? So it's quite legal to do that. And it's good. That sort of evidence is good. If you think about it, you'll have other examples as well, like maybe doctor's reports, if you've reported something to the doctor.
Can I just point out as well, if you're in a different country, the rules may be completely different. So that's for Australia specifically. But if you are in Australia, and I know the rules are slightly different in every state for the phone thing that Mum was, so don't go and get your own legal advice for phones. But it could help as well to record conversations, etc., to show to the police. If the police don't believe you and you've got recordings, even if you're worried you're going to get in trouble by the police, if you've got those recordings, forget about court for a minute. But if you're dealing with someone who's going to do DARVO and all of a sudden call the police on you, you've got the recordings so you can protect yourself as well. So that's something that's really important. And they gave a larger percentage of the property pool to her, didn't they?
I think it was a 14% uplift because of what she'd been through since separation.
Okay. What about, this is some questions here for
Okay.
when the system doesn't listen. So this question is from Help. And I know we're just talking about the police and how they sometimes miss it and they don't get it seriously. So what can I do if my lawyer says it doesn't matter with regards to coercive control, family violence, and the like? So that's Help's question. And so many people, Mum, tell us, and we call it legal gatekeeping, we've decided.
We do.
Where the lawyers go, no, we're going to take that out. And we've discussed this before, haven't we, Mum? And Krasi, I think if the lawyer doesn't either, one, know about the new changes, two, doesn't have the kahunas, or three, is just, this is sad, but some people buy packages from their lawyers. So it's a package deal to get a divorce. And this happens with those ones where it's joint as well, but they buy a package deal. The lawyer only is going to give you a certain amount of money and a certain amount of time. If you start saying things about coercive control or family violence, they don't want to deal with it because they know it's going to make it a little bit more long and expensive, and you've only paid them an agreed package deal. That's just my sights. But Mum, what do you think about it when the lawyer doesn't want to take on board the coercive control?
Well, I think you either show them cases like Sharman, and Hannigan is a recent case as well, and you point out to them that if you're filing in the family court for children's matters, you must fill in a notice of risk or abuse, and that includes any towards you. So if you're going to say nothing about it in your correspondence or even in your affidavit, you will have to reveal it in this document or leave it out. If you don't have that early raising of these issues, you're not going to have much credibility when you get to court. So you may seem like you're crying out in the wilderness, and you may be the only one in your circle who really gets it about family violence and the coercive control. But you do need to put it in.
So, Mum, should Help maybe get a second opinion?
I think Help should just look at a couple of cases and see if what her lawyer's got to say about that. I don't know what extent your documentation of it is. The other thing you can do is do some headings and make a statement of all of the issues that you have and some vivid examples and things like I've got footage, or I've got the receipt from where I went to the doctor, or I've got the note, and assemble it all and give that to the lawyer as a total thing and say, now, looking at that, do you believe that we should leave coercive control out? And then you might refer them to section 43B, I think it is, or AB, where the court says that the court must, the law, it's in definitions, but the Family Law Act says the court must take into account family violence. So to not put it before the court is to run the risk of getting a wrong judgment for you.
Okay.
I have a question. Can I ask a question of Lynn as well? Because I hear it quite a bit come up for the people that I see as well. And so the situation quite often might go like this. Either the lawyer seems to be holding themselves some unhelpful beliefs around coercive control and domestic violence, and it does become obvious over time that they're really not on the same page with the client, or it might be that the lawyer just simply doesn't have enough understanding and has not been educated enough in that area. So the client might feel like they're literally educating their own lawyer, and that's not really where you want to be. It doesn't give you the confidence, and it takes up a lot of energy. So yes, so in those situations, I will often have this discussion with the client. Is this the best person to represent you? What's the cost of potentially looking at another legal representation? And I know people get quite scared if they're, let's say, halfway through already a case. Can I switch? What's going to happen? What are the repercussions? So what would you say, Lynn, in situations like that?
Look, if you still have confidence in your lawyer in other respects, it is expensive to change.
What if they don't? Yeah.
Okay, so if you don't have confidence in your lawyer, you can either ask them to get a second opinion, a barrister's opinion, and see if that sort of changes their tune. But it is going to be so much harder pushing against your lawyer first to get the information in, and it may be time to change. It may be that you need to change your lawyer. And the lawyers, talk to whoever it is you're thinking about sending your file to, get them to agree that it'll be a fixed number of hours to revise your material. so that they know where you're at and get them, and then they can act for you from.
And they can do, particularly people going through coercive control, the heart-stopping moment would be you telling them, you've got to go now tell that big scary lawyer that you no longer want them to be your lawyer, and can you pass on the files to another person?
No,
people who've been through control do not want to do that. So you go to the new lawyer, you ask the new lawyer, you say, okay, I'm going to work with you now. Can you please get my files from the other place? They'll probably have something for you to sign. They will do all the work with the other law firm. You don't have to be involved. Obviously, there may be a bill you have to pay before they hand the stuff over, but that is the best process. So I think the warning sign for anyone listening today who is experiencing coercive control or have been through family violence, who hasn't chosen a lawyer yet or is about to, if you don't shop around, you might get stuck with an expensive mistake. So make sure that you know that they're well-versed in it, that they understand you, they listen to you, they hear you. And if you feel in your bones that they don't, you don't want to be walking down 6 months from now, walking into a courtroom with them, not thinking they have your back. You want to have someone who you really know has your back. So it is better to pull out sooner and get a new lawyer than later. So that's a good reminder for everyone.
And imagine if that lady had not put her experiences in the affidavit that the judge was able to identify as coercive control. Imagine if someone had stopped her putting that in her evidence.
Yeah,
it would change everything, particularly where kids are involved.
So true. All right, let's get to Katina's question. She said, I made a police report about my ex's abusive behaviour. When the policeman asked me if my ex had any controlling behaviours, I listed all the coercive things he had been doing. And the policeman then said, well, I guess the answer is no, as he has not been stalking or tracking your phone or whereabouts. Should I make another report to a different police person who is trained in this behaviour?
Oh, my goodness. Yeah, yes, dear, you should. Yeah. But good luck with that, you know. And again, look, to any men listening to this, I have lovely sons. And I have a lovely husband, and there are good men in the world, and there are good men who can be subject to abuse. But the reality is for women going through this, that when they walk into that police station, the person in charge of the police station is what we would call pale, male and stale. And that sergeant's been around for years and years, and they've gone through and they've probably been there through the period of time when they'd go, oh, we can't get involved, it's domestic, and men would beat their wives black and blue. Then it went to, oh, well, show me the bruises and we'll act. And they've got a little bit further on, but they've still got to learn this coercive thing. And you can't, I've heard of stories where the young officer at the desk completely understands. They go in and talk to the sergeant and come back and go, no, we can't. So if it's Queensland, we can dob on them. I don't know that we don't have any contacts in other states. But yes, you might try that. What's that? Is it ARC? What's your program, Laura, that you can write in for to document things online on the police thing?
Empower You. But yes, the Empower You app helps you document all of the things that are happening to you. The police don't get involved in that unless you show them. It is run by the New South Wales Police. But what I can say, Katina, is that unfortunately, like Mum said, it's every single individual police officer is different. They are trying to train them. They are trying to do the right thing. But again, the same with judges and registrars and lawyers and barristers and everybody. There's all different levels of understanding because there's different levels of education. The best success I've heard for people, and maybe Krasi, you can step in here in a minute, is people do shop around as well as shopping around for lawyers. They shop around for a police officer who has their back. And if that means you have to move the station when they move to a different station, then you go to a different station. And there are, if you go into some domestic violence and family support groups, there are known stations to avoid and there are stations to go to. Particularly in lower socioeconomic areas, they seem to take it a lot more seriously than they do in the higher economic sphere. That's what I've been hearing. So if you want, and they have more training in those areas. So maybe go and find an area or go and find a support group and ask around where's the best place to go. But the most important thing is to not give up because you need to get that reported. And I have heard many times of people who've tried to report it and they've been dismissed and they go into a different station, they report it and they are taken very seriously. So, Krasi, have you got anything you want to add there?
Yes, sure. That's been my experience as well, that there are certain police stations that seem to consistently do a very good job of it, and they have a very deep understanding. And then there's consistently police stations where you get dismissed. And I think this particular instance exemplifies exactly that kind of tick box approach, where we've got 3 things maybe on our list of what coercive control looks like, which is the stalking behavior, the tracking your phone. And if you don't give us exactly that, and I can tick those boxes, then I can't make sense of it. But it does have very significant repercussions, because sometimes that's the pathway to obtain an intervention order. So it's not even just I want to have it on record. If the police is not going to support my application, then what do? It doesn't look good. So that's why it does matter to find someone who hears your story. And I think what can be beneficial as well, I hear, is that when people are connected with a caseworker from domestic violence service, then part of what they can do is they can support you in regards to the police. They can come with you. They can liaise on your behalf as well. So it might be worthwhile getting in touch with the local domestic violence service in your area and seeing whether they can help you with that as well.
Yeah. We've got an episode with Melissa Dwyer, who used to be the head of the Vulnerable Persons Unit, Domestic Violence Unit. Unfortunately, in Queensland, they have axed that area and merged it with all the other crimes. Unfortunately, she's not in charge anymore, but what she says in that episode still stands. She walks you through step by step what happens when you walk in the door. And for anyone who is nervous or worried about doing that part of the process, this would be a really good episode for you to listen to. All right, I'll put that in the show notes. All right, let's go to Roberta. She says, what are the chances of being granted a protection order when the PUV, person using violence, explains everything away? Can you talk about the likelihood of costs being awarded if no protection order is put in place, and how much evidence would be required?
So I guess that was for me. Yeah.
Yes.
So, Roberta?
I just ask, just in case Roberta didn't mean costs as in costs that you're talking about, just in case this is a question, and I'm interested to know too, what are the chances of getting, was the flip on it, what's the chances of getting a percentage change in the property settlement or less time with the kids if there's been no protection order but there has been family violence?
Oh, I don't think that the existence of an order or not actually proves family violence or not.
All right, so for those of you who are worried, because I do hear some people going, I have to go to DV court because I need to get a protection order so that they understand it in the family court. But what you're saying, Mum, is that's not necessary, that the court will look at its own evidence. It doesn't need the family violence order to prove it. Okay. But if you need one, go get it.
Yeah, but I think there's 2 different roles, you see. The family violence orders or apprehended violence orders are there to keep the other person, to stop them doing the things to you that they have been doing, and to keep their distance and not commit further family violence. The family court's focus is almost retrospectively. Normally, you're out of the relationship by the time you get to a trial, but what they're looking at is, how did this impact on you in the past? Have you still got any effects from that in the future? And they will also, when they're looking at kids though, they'll look at past behaviour as an indicator of future behaviour. And it will have very serious consequences for the kids, whether or not you've gone to get a family violence order.
Perfect.
It's quasi, it's too hard, isn't it, for some people? It's another front.
I know, it's too hard, and I think that's been the big issue for such a long time, that they're just sometimes what feels like completely separate, disparate systems that don't really talk to each other and don't translate to each other, because I know things that have even been made as decisions in a criminal court don't seem to really carry over in decision-making in family court. And I have seen plenty of times as well that there are 5-year intervention orders that have been granted, including sometimes the children are on it, and it still doesn't seem to have a very significant impact in then the decisions that the family court makes as well. Yeah. I don't think having an intervention order is a guarantee that the domestic violence will be recognized and seen necessarily.
And jurisdictionally, just for a little legal background of it, the thing is that apart from WA, who is almost exactly the same as the rest of us, Family Law Act is Australia-wide, but each individual state government and territory have their own laws about family violence. And so that's why I think it's a little bit trickier. You may well have to tell your story again in the family court to see what they make of it. I think we get police files The court gets copies of police files and they can see if someone's been charged with a breach, and that is very significant. But sometimes it's just, for whatever reason, you haven't gone and got a protection order. It's fine. Just tell the story of what happened.
Okay. All right, let's get to some of the questions that we got sent through about what happens if the control continues after you've left, through the lawyers, through the courts, and through handovers. Because we hear this a lot as well, that people, they finally get their orders sometimes, or they're finally left and they just won't stop. So what things can we do? Need to start doing your disclosure but have no idea where to start? Feeling overwhelmed about mediation coming up? Or just trying to deal with negotiating with a manipulative ex? Then you need to go to thedivorcecourse.com.au to go to the free resources section, where you can get a mediation checklist, a disclosure checklist, a word salad, read a letter like a pro checklist, and also a before you go checklist. Get ahead of the game and be organised and ready, as this handy checklist, along with the accompanying episodes of the podcast, will be perfect for you. All you need to do is go to thedivorcecourse.com.au and go to the free resource section and download the free checklists today. So Samantha's question for you, Mum, and then Krasi. What can someone do if they're experiencing significant post-separation coercive control, even after parenting and property matters have been finalised and a divorce has been granted? What legal protections, support services, or practical strategies are there available to stop this ongoing form of abuse?
Yes, it's tricky. I think that it's difficult to get a court order to stop this form of abuse, but you may have to, or you may have to threaten it to go to your court, because it's blurring into the lines. I don't want to endorse what that police officer said, but is it stalking? Is it surveillance now? Are there cameras? Because you're no longer under one roof with these people. You've got your finances separated. The children presumably are out of danger. So it is that your ex is almost no different to any other member of the public who harasses you.
You did have a case though, didn't you, where they had orders and the parent they were only allowed to communicate about children's matters, but this person had communicated like 100 messages in a week, and you were able to point out to the judge what was it?
Oh, it was, I counted up the pages and then averaged out the words. It was 1,500 text messages that he'd sent over a 3-month period. And there was an order that said he's only to communicate with the lady about the children. So he would say so much intrusive thing. I see you were at Chermside yesterday, and, what did you buy? And how's your new boyfriend? Oh, and how are the kids? And every one of them had that little line in, and that was protection, he thought. The court was going, oh, Mrs. Galvin, that's not very much. But when I held up the printed out ones and gave the number of them and the period of time over which they were sent, the court readily saw that was excessive and quite wearing on a person. When you no longer have to deal with the kids with them, my dear, you don't have to have your phone number that they know anymore, and start to separate your life from them. But they're liable to the same, I think they're liable to the same punishments as the general public. And they also, by virtue of the relationship that did exist, you probably can go down the family violence route.
So, Krasi, have you got any suggestions for any practical strategies or help in this regard?
I agree with what Lenny's saying, that it doesn't really matter whether it's after or during or before proceedings. It's what they're doing that matters. So if they're engaging in, for example, stalking, monitoring, if they're parking outside at 2 a.m. in the night, then those are grounds for applying maybe for an intervention order again. Doesn't matter that the court proceedings have finished. Also, domestic violence services absolutely recognize post-separation abuse, so you can always reach out as well, get a safety evaluation, get a case manager going, get some advice on what options you have. So in many ways, it is the same kind of support. I want to speak to the question in terms of what strategies are available to stop the behavior. There is a limit to what you can do. There are certain things you can stop with an intervention order, like the stalking and so on. But if someone is using the parenting app to send you 100 messages a day supposedly about children, but really it's not, that different. So I do want to acknowledge that there is a variety of strategies and techniques that can be used, and some are easier to stop and prevent through official channels, and others, they do them on purpose because they know that they're skirting right on the line of what is acceptable and what is not going to attract any intervention externally, and they know it.
The grey rock strategy. The grey rock strategy is a good strategy to use if you're out of court, if you're finished, if you just flat ignore them. This is one thing that I've heard that does work. Over time, they get tired of it because you're not giving them anything back.
Or move on.
Or move on, yes.
On
or
with
they move on to somebody
new
else.
family, new partner, yes. But it's also important to recognize that if they're still preoccupied and there's still a sense of escalation, then there is a risk management that needs to happen at that point, because that is also a possibility that they're not moving on and they're showing that escalation exactly because they feel maybe they've lost control. They haven't got what they wanted out of the court proceedings. So in that case, I would definitely be encouraging contacting police or a domestic violence service as well to help you with the risk assessment and management.
Definitely.
One of the cases I was... Oh, sorry, darling.
Yeah, you go.
One of the cases I was reading yesterday, it was the woman couldn't get a family... She had a family violence order. She couldn't get the partner breached, but he was always filling up his fuel at a service station that went over whatever the distance he was to stay away. He would stand on the right side. He would stand more than 100 meters from her work, but where she could see him. All things that were just so irksome. But interestingly, because I'm reading the judgment here, right? And in the judgment, the judge listed all those behaviours as of someone who's prepared to push the envelope. And it was interesting. So he's the one who brought the application to the family court, which is often the culmination of systems abuse or post-separation family violence. They say, oh, well, I'm going to go to court and get more time for kids. And this lady documented those behaviours. The court read them and actually he was having weekend time. He went away with no time at all.
So that's important, Mum. I think what you've said there is, even though the police can say, oh, he was 110 metres away, there's nothing we can do about it, you documenting, you provide all that evidence to the court and they will have a different opinion. You've got to remember, I think, the police's opinion is different to what a registrar or a magistrate or a judge is going to say. So just because a police officer tells you something that's not important doesn't mean it won't be important for you. So that's a really good, important point, Mum. Let's get on to Anonymous, different Anonymous. What evidence and documentation best help distinguish a genuine pattern of post-separation abuse, coercive control from ordinary co-parenting conflict, particularly when the behaviour involves responsibility shifting, creating administrative burdens, repeated court threats and last-minute demands rather than just overt intimidation? So we do see this a lot, this whole attack on people by just lots of messages, lots of demands, changing things, causing problems, and that responsibility shifting. So let's go with Krasi first. What kind of evidence can you help? What things should you be looking for to document this?
So this question really speaks to that key question about when quite often I think the court and external sort of parties, they really conflate what is a genuine pattern of coercive control as just mutual conflict or poor communication between parents. And that's where the difficulty becomes. How do I show that there is intimidation, there is attempted burden being put on me, there is undermining and maintaining control, and that's not conflict, that is something else. So the focus really needs to be again on demonstrating the pattern and also what is the function of that pattern, what is that pattern of behavior trying to achieve, not focusing on catching individual incidents in isolation. And when I say what is the function of this pattern, so you're trying to answer the question, is the behavior designed to really create fear or create confusion, exhaustion, depletion of resources? Is it undermining the relationship with the children? Is that what this is trying to do? Also, is there a repeated ongoing transfer of practical and emotional labor from one parent onto the other, so that one parent is carrying a disproportionate burden overall? Is that what this pattern is showing that it's doing? Are there demands and these kind of crisis situations and this constant conflict really around important dates all the time, or transitions, or just some moments of autonomy for the victim survivor? that can show a pattern as well and functionality. And even those court threats or the last minute requests or changes or ever changing expectations they are doing, again, do they have a legitimate purpose for co-parenting, or are they designed to maintain ongoing control? So you're trying to look at the whole pattern and demonstrate it, and also what is it trying to achieve? What is the function underlying it? And also you're trying to really talk about a cumulative impact. It's not just the one thing that happens today. It's because the thing is happening every single day in the space of weeks ongoingly. That creates a different kind of impact and harm than if we just look at it as a one-off.
I think, Mum, we'll get to you just in a second into this question, but I think if anyone's listening who isn't up to final orders yet, this is a really good reminder to look at, because I see this a lot with coercive controlling co-parents, this administration burden. They use it as a way to continue the control over you. So they may deliberately not get a login to the school's information so that you have to provide every email, every report card, every teacher letter, and they'll email you and say, have you sent me this yet? Have you sent me this yet? So think about in your court orders when you're going for parenting, what things in there could they potentially use to always have you on that leash to continue to control you and make you do things administrationally, particularly around the children? And what can you do in a way that takes that burden off you, and maybe the emails get sent? For example, if you use Our Children, you can get a joint email address that anything the school sends goes to that email address that then gets split to your email and to their email. So you know every time something's sent, it's theirs, they've got it. If they don't read it, that's their fault. And they may probably complain they never got it, but that you've got documented proof they've got it. Report cards goes to both. Just take some of that control that they could use against you out of your court orders before you get them. But Mum, what kind of things can people do to draw a line showing the difference between just fighting co-parenting stuff and deliberately crazy coercive control?
Well, sometimes a person who exercises coercive control over you, when you have left them, the only weapon they've got left is the children. And if they are not, they don't love their children, they can use them this way, in a callous way, but they're using your love of the kids to get you, in a mess and to upset you. So sometimes I think when they put those pressures on you of things, do this, do this, do this, it can sometimes be used to demonstrate that they've never been the primary carer and they aren't capable of, following a routine or getting whatever it is, getting off work or taking these medications or getting medications for the kids, all that stuff, or they don't do their homework. And it's interesting. One of the court orders that we used to make was that the person who had the kids would send the school newsletter, would send the school photos and would send the report cards. We used to do a lot. And then the law changed, not the law, but the practice changed. And now we say that each party be at liberty to get the information directly from the school because they've recognised there was that burden on them. So, yes, I think if you're getting a lot of that sort of work from them and a lot of admin load from them, there's no harm in saying, look, for the last writing to them and saying, for the last so many months, you've been sending these letters and I want you to know that as of this date, I will expect you to get your material directly from the school. And if you need to give authority, put that authority in and just put it all back in their court.
And if they keep doing it, you've got the letter to show in your affidavit you asked, and then the continued abuse and the behaviour after where they continue. All right, let's move on to Jenna's question. She said, I'm in the depth of post-separation abuse. His lawyer is constantly gaslighting and minimising my experience and its psychological torment. How do I deal with this? Krasi, did you want to say something before Mum gives any tips?
Oh, it's awful because when the lawyer becomes the mouthpiece and it just regurgitates the same kind of untruth and manipulation, I think that must be highly unethical. I don't know what the professional sort of regulations are around this kind of behavior, but I've definitely heard it, including just taking on these very false, unfounded claims and untruths from their client and just putting them in legal letters as if they're absolute truth and they're fact-checked, which they are. In my mind, it seems like either if you're savvy and you know how to deal with the lawyer, then probably you can push back on that and it would be the cheaper way, or you can just ignore probably a lot of those untruths if they're irrelevant. I think they put a lot of emotional stuff and they can sometimes make very big stories that probably are very irrelevant to the core of what the issues are. And also, if you have a good lawyer, they're the best buffer, I think, against these kind of things. And I know sometimes my lawyers have this understanding with my clients, have an understanding with their own lawyer when they're getting these kind of communications, that it's the lawyer that always gets directly the communication and they'll screen it, they'll see what's relevant, and that's the only part they'll send to the client rather than the whole 5 pages of awful, harmful stuff. And that's been really helpful to people, because if they trust their lawyer, they know, okay, if it's something important, they'll tell me. If it's not, then I probably don't need to see it. It's only going to be upsetting. And that seems to work also quite well.
Because, Mum, it's horrible, I think, for some of these people who they've had to deal with their ex making up crazy stuff, and they're probably in some ways used to their ex saying stuff like that. But when you go into the real world and these people are now hearing it from official professionals in suits and looking like and going, oh my goodness, this furphy or the BS that they're making up about me is now being read and said by official people who are smart and intelligent, and I don't want people to think this about me. So, Mum, what kind of things legally can Jenna do in regards to a lawyer who's become the hand from the coercive controller that's reaching in?
It's awkward. Jenna, I'm sorry this is happening to you, because lawyers should know better, particularly lawyers working in the family court space.
We have in our family court companion course, we have a whole lesson on bullying and dealing with lawyers and other professionals, and we have some template letters that you can use. So yes, if you're interested in that, Jenna, that will be coming out soon. It's just in a beta testing at the moment. We've got some lovely people testing it for us at the moment, but that will be available for people who are going through the family court system, self-repped, having to deal with that kind of stuff. We know it's tricky, so that's why we've got some wonderful letters Mum's written. So, all right.
I can remember someone keeping a letter from me in my family court matter because they didn't want me to get upset during work. And then I was agonizing over what's actually in it. I think your clients who having an arrangement where they don't get the whole letter, I think that could be a bit tricky when you got to trial, because these letters are to be given to you to get your instructions on. And an example of how I certainly train.
Or maybe they'll highlight the sections. They'll really highlight the sections that they need to attend to. Not that they edit the letter, but they'll highlight and say, don't worry about the rest.
Okay. Don't worry about the rest.
Yeah.
Yes. Well, and so you get these 5 to 5 on Friday letters that come through, and what they want you to do is send it to your client, so the client doesn't have any support over the weekend.
Yeah. Okay. Now, this question is from Lee, and I'm not going to read all of it because I think it's too triggering, but I do feel that some people listening today may feel that they're at this position because we're talking about the coercive control and the abuse continuing after. And there is a fear that Lee has based on the issues with her teen and the visiting. Obviously, the teen is not wanting to visit the other parent all the time. The other parent is doing some surveillance, some stalking, some videoing, some horrible things. But poor Lee is freaking out about the thought of having to go back to court again. And there is a big fear, I think, Krasi, I don't know if you see it in people who have been through the court system and are then absolutely traumatized of thinking of going back, or people who are who are absolutely scared of going to court at all. So how do you live with that ongoing intimidation after final orders, or it maybe even before you've got orders, and worrying about the going to court part? Is there anything you can do to help Lee to manage that fear?
Yeah, I think because I know what the question is, Lauren, I've read the whole of it as well. I think it's very important to mention as well that the teenager is 17 years old, which is Yes. So in that case, I think it's one of those situations where the fear just lives there for such a long time, even when there's so many more options that maybe weren't the options a few years ago when the separation started or all of this went ahead. Because if a 17-year-old is having such a strong response and reaction and fearful feelings about meeting with the other parents, then it probably is better for them at this point to fully step away, to have some distance, to have time to strengthen and heal and make up their own mind about what they want with this relationship at this point. So it is important to give that option to this, not even a child, he's a teenager, almost a young adult. Yeah. And the fear of court, I don't think, and Lynn, you can speak more about it, but it doesn't seem to me like it's an actual reality in terms of, what they would have to go through. It might be more that the fear of having to face the anger of the father if the son stops engaging with him for a while. That's what's really driving that need to keep placating and keep those visits up. Even if it's a parent, if they're engaging in some significant stalking and fear-inducing behaviors, then a teenager can absolutely present to a police station as well, and they can request an intervention order. And I've heard these kind of cases, and the police really listen when it's children, again, a teenager involved. So that might be potentially an option to really put the barrier and put a stop on what's happening. But I think with such strong reactions, that really should be happening, and they need to be supported in figuring out how to step away from this relationship for a while.
Yep. And 17, no, they can't. He can't take you to court to make a child who doesn't want to see him, right? Yeah. So, and Rice and Aspland was the case that said you can't keep going back to court with children. So if you've got final orders, you can't go back to court unless something dramatic has changed. And I can, I actually, it gives me shivers to imagine the reaction of the first court officer who, registrar or judge who opens up that and sees trying to find a case or trying to get an order for time or a contravention order when it's a 17-year-old child. And if he's going to go to court, Lee, even if he wanted to, you could hit him for costs. But I think he must invite you to mediation and he must try to negotiate it first and give you a notice of intention to file. So I think, Lee, that you are out of the woods. It just doesn't feel like it yet. And as soon as your young bloke turns 18, then you are in every respect completely out of the reach of your ex. And then if he is stalking you, complain to the police, ring them up. So there's a man out there.
Block his emails,
house.
do all of those things. And I really want to point out to these type of controlling people who've controlled every aspect of your lives, the legal avenue and the court avenue is the last hooks they've got left. Once your kids are old enough to do whatever they want, they've lost that hook and all they've got left is your fear of court. And it's their last hook and it's all they can throw at you. And like Mum's saying, if you went to court, most likely it would be laughed out. So just
99%.
99%. Just remind yourself that those hooks that your ex is trying to get to you is that fear of court and that he's trying to manipulate you to do what he wants. But if he's sending you all those emails, if you can, if it's safe, then send it to spam, report it as junk, get it out. You don't need to respond, but you need to create some healthy boundaries and remind yourself this is his last way of getting to me and he doesn't have the power. But because you've always been in those situations, it does feel so scary. But it actually, as Mum and Krasi have just said, he doesn't have that power at all.
Your child is 17. He can have his own communications. It's not involving you. So he just needs to stop.
Yeah. Let's get to the last question we have today. And it's from Gina. And I'll get Krasi and you, Mum, to answer. Mm-hmm. When you're living inside coercive control, nothing feels dramatic enough to be believed. But everything feels too relentless to ever stop documenting. What are the actual thresholds legally and psychologically where police and courts start taking separation abuse seriously? And how do survivors know what evidence is enough?
What is enough? I think, again, when we think about the kind of pattern and the complexity and the individuality of it, because what coercive control looks like in one relationship may look very different in another relationship. It doesn't look the same. Even when people are thinking, is my case the same as this other ones that I've heard and that's been on the news or that's been described in a certain court case, and mine doesn't look anything like it, then what do I do? How do I prove it? So there is the difficulty of that. And the reality is that it's not just about how well you say it and what is it you say. It's also about who's listening on the other side. And there's only so much you can do about controlling that part of the equation. And we already spoke that some professionals and people who work have a lot better understanding than others. Some have none, sadly. I think there's quite a few of them, but they do exist. And some genuinely hold harmful beliefs as well. So you have to remind yourself that it's not just what I say, it's who I'm saying it to, and I can only affect the part that falls on me about saying it. And if they don't hear it, it's not always on me. It's not because I'm not doing a good enough job of it. But psychologically, in terms of what the threshold is, because I think we're talking about different things, what the threshold might be for police or for family court versus psychologically what I know to be truthful for people. It really should be about the level of harm and the intent that's put behind these behaviors. Now, intent is very difficult to prove at the best of times, but it is.
Sorry, Krasi, but the court has been very clear. We do not need now to have intent as part of the.
Yes, but for example, in New South Wales, in terms of coercive control being criminalized, they do require intent, for example. Yes. Yeah. So there are all these different thresholds depending on where you go. So if you go to your therapist, you don't need to prove anything to me or to your therapist. We will see what the harm is. We hear your story, and that's enough. There's nothing more you can say. But if you go to a police station, obviously they require particular kind of evidence and maybe proof of intent. If you go to family court, it's different. So intent is very difficult to prove, but I think it's very easy to deduce when you understand the relationship dynamic through the lens of what's the functionality here. Who holds the power in this relationship? Who benefits from the status quo? What are the consequences for expressing dissent in this relationship? If you use that lens to really look at the dynamic, then intent becomes easy to deduce. Now, the difficulty as well with harm, and I think that's also what can come out when trying to prove it, is that harm first is cumulative over time. What happens early on is not what happens later on and after a long period of time. And also it's very easy to conflate harm with individual symptomatology. So once you're going through family court, it becomes easy in some ways to weaponize the harm that is observable as the cause for a lot of these situations rather than it's the consequence of harmful behavior.
So can we just unpack that really quickly, Krasi? So what you're saying is, and we have talked about this a lot, the court doesn't do it, but sometimes the abuser, they say, look, see, she's paranoid, or he's crazy, but the person may be paranoid or crazy now because of the abuse that they suffered. But they turn the effects of the abuse to the person in the court. Is that what you're saying?
Yes, absolutely. That's exactly what I'm saying. And I think the most basic way to explain it, I don't know if it's a great analogy, but that's how I think of it, is imagine if you're trying to run in a marathon and someone next to you is constantly kicking you. And because they're kicking you, of course, it's causing harm, it's causing injury. And so you start going a lot slower. And then they turn around and say, you're so lazy, you're so no good. Why do I need to keep kicking you to make you go faster? And they kick you even more because now that's their excuse. And the more they kick you, of course, at some point you even collapse. You're not going anywhere. And then that becomes their justification. See, you're so bad, you can't even run. You're no good for nothing. So it's what they're doing, the harm they're causing, that is the reason for you failing, so to speak, or you experiencing injury and damage. But then they use that to claim that's exactly why I needed to be doing what I'm doing the whole time. And to an external observer, if they don't see the moment when they kicked you, all they see is you injured or faltering, then that becomes the narrative and the story. And that's what I'm saying becomes the difficulty, because these things happen very much in private. There's very often little evidence to show a lot of it. They're packaged in ways that don't appear harmful on the outside. It's because they happen so repeatedly over a long period of time. So that also, I think, confuses people and makes them feel like they can't prove it and they can't show it because it becomes conflated. The cause and the consequences become conflated.
So when is it enough? And I'm just going to put in there, unfortunately, until it's over, I don't think you should ever stop documenting. And you might think, okay, I've got my final orders, things are going fine, we're all following them, everything. I don't have to do that anymore. And then you may find, and I don't want to upset anyone, but you may find there'll be flare-ups. There may be, I don't know, changing to high school. There may be a big flare-up then. There may be you get married again. There'll be another flare-up then. And everyone listening to this is going, I'm never getting married again.
Yeah.
But, there's all these little incidences that will continue to spark potentially your ex's bad behavior. And one, two, three little incidences, you might be, I'll just deal with that. But if it keeps happening every time a major event in your life happens or a major event in the children's lives happen, if you've got the proof and the pattern that their behavior gets bad at these incidences, it's good protection for you to be able to go back to court or get a protection order. So I don't think you should ever stop documenting until they stop behaving badly. And I know the documentation fatigue does set in because one, you've got to suffer it and then you've got to document it. It just seems like you're asking a lot from people, and I know we're asking a lot from you. That's why I do think that Empower You app by the New South Wales Police, it's free. You download it on your phone. They send you something horrible, screenshot it and put it in the app. You put the date, it puts the date for you. You put how it made you feel and what was the scenario, and then never think about it again. If they slash your tires, take a photo of that, put it in your phone and get your tires fixed and never think of it again. But all of that printed out, once they have one big tanty, that's enough for you to go, this is too many times, go back to the police, show them all the behaviours, and that documentation that may have taken you a couple of seconds to do will be a lifesaver for you, metaphorically, with having to go through and do all the paperwork. So I never think you should stop until the behaviour stops. You never know when you're going to need it, but I know that it is such a lot of work, and my hat goes off to all of you who are trying to figure out how to get this across. But I think the crux that we've all just talked about this whole time is tell it. Doesn't matter how you tell it. It does help if you tell it well, but at least tell it. So if all that you can do is just say exactly what has happened over the last couple of weeks or months, do that. If you can go and see a psychologist like Krasi or someone who can help you organize your thoughts, that would be helpful. You can listen to our Documenting Coercive Control episode where we take you through the headings we recommend you try and use. There are lots of ways to get yourself moving through writing it down, but the easiest way to get it written down is to have something that's on your phone that you can bring it all up and just start listing it out, as opposed to sitting down 6 months later, just before trial, trying to figure out what happened last Christmas at handover. So it's a lot of work, guys, and my hats go off to you. And I'm sure, Krasi, you've seen some of your clients going through it.
Oh, it's exhausting. I feel for it because just when people need to stop and pace and be as far away from this information as possible, because recovery-wise, that's what would be best for them if they never had to think and look at this ever again. They have to do exactly the opposite, which is just plunge themselves into all these memories, all these instances. So I know it's very hard. It's really not ideal.
And Mum, lawyers hate doing it too. I don't think any lawyer sits down and goes, great, I can't wait to write this affidavit of this horrible situation. So lawyers struggle to do it too, don't they?
I think some lawyers do.
I
don't hate it. I don't hate it.
You're special, Mum. You're special.
But for your client, I found for my clients, particularly if the other side filed an affidavit first, it's full of allegations and false things. And their affidavit, which I helped them draft, naming all of these behaviours and refuting things, when that gets filed, the clients feel so lifted that their full story is being told. Yeah, but until they get that final trial affidavit filed, the other person's affidavit feels like the only version of the truth that the court has got. But I find it quite, I enjoy it. I enjoy writing things and that, but I am a widow, and some judges, as some lawyers, can find that hard. That's why I say, if you guys are documenting it anyway, put it in a document, in a Word form or whatever, so it's all written out. Give it to your lawyer if they're drafting you an affidavit and say, there you go.
It's a present.
Here it is. Put that, insert where it says, has there been family violence?
Mum, what would you embroider on a cushion?
That's a bit hard. I think,
Krasi?
I don't know, darling.
What would you embroider on a cushion?
Tell it. Yeah.
Oh, I would embroider. I was really heartened to hear not that long ago a client of mine tell me when they went to the magistrate court for an intervention order that it was, and they were so nervous about whether what they had as evidence was good enough and whether they would make sense or they would just be seen as this paranoid, crazy person there. And it was the magistrate that actually turned towards the lawyer of their ex-partner and said, "Have you heard of the term coercive control? I don't want to hear anything else from you." And the intervention was granted, and it was such a great outcome. So the fact that this is happening means that something positive is filtering through, the information is filtering through. So you gotta be hopeful. You've gotta stay on the right track.
Okay, so the question is, have you heard of the term coercive control? Perfect.
I love it.
Perfect.
And you guys are, those of you who are going through this, you're the leaders for future generations. You're the ones educating the lawyers and the judges, and you're the kind of suffragettes going through. And it'll be easier for following generations.
Right, give them another job to do. Document, be a leader, be a suffragette. But I understand, Mum. That's the reality of it. You don't feel you have to take this on for everybody else now. Oh. You've got to get yourself through it. You've got to get your kids through it. But then maybe you could write your experiences down and share it when they do the Royal Commission, hopefully one day, or some sort of, studies. You can put your hand up and say, actually, this was my experience. And that will, if everyone speaks up and if everyone shares their experiences, hopefully Australia can become a better place and hopefully the world. And these kind of poopy bums can go away. So thank you, Krasi, again for your time. Next week, we will be talking about our final episode, and that is the healing part, because once you get all the way through this, how the heck do you heal yourself and repair the damage that has been caused? A reminder too, guys, that Krasi has an event coming up where she's going to be speaking to all sorts of people. I'll get her to explain it in a minute. There is a link in the bottom of the show notes where you can share your experience anonymously. And this is one of those examples of the times that you can do that to help shape the way the professionals deal with coercive control. So Krasi, can you just quickly tell us a little bit about that before we go?
Yes, thank you, Laura. I will be speaking in a few months at the National Australian Psychology Conference on coercive control, and I'm so keen to hear from people and hear particularly what their experiences have been with therapists, psychologists, just people in my profession, so that I get whether they have been good experiences, bad experiences, what's been helpful, what's been a defining moment either way, so that I can use people's words and experiences to really try and shape what's happening in our profession. And I think it can make a huge difference. And I've already had a look through what we have received as responses, and it's just gold. It's pure gold in terms of what people have shared. They've really put a lot of thought and time and effort into it. And I think it makes a huge difference. And I think if that can be used as future training for our profession as well, that would be amazing, because it's the kind of information we need to drive that change.
Wonderful. All right. We will see you ladies back next week for repairing and recovery from coercive control. Thank you so much for your time, Krasi. And Mum, as always, thank you so much for your time. Bye,
thank you. Bye, Krasi.
Thank you.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording